So let me, without further ado, let me begin by introducing our panelists. First, I'd like to introduce Professor Ronen Avraham, who is a professor of law at Tel Aviv University and a senior lecturer at the University of Texas. He is a leading and widely cited scholar on tort law, insurance law, and has a particular focus on economic analysis of law. He's also written extensively about third-party litigation funding. Professor Avraham has had some logistics challenges in getting to Salt Lake City and has agreed to join us by, from Israel remotely. And just so you know, Professor Avraham, we can all see you. Can you hear us okay?
Yes, I can hear you very well. Hi, everyone.
Great. You're coming in loud and clear, and there's a big, giant picture of you just behind us on in the auditorium. So thank you so much for joining us, Professor Avraham. Next to my left here is Eric Schuller. Eric is the president of the Alliance for Responsible Consumer Legal Funding. The Alliance is a nonprofit trade association that represents consumer legal funding companies and scholars and advocates from around the country. It's very knowledgeable and has a deep background in all of the ongoing legislation and litigation. We've just been having a fun conversation about consumer finance regulation and other consumer legal funding rules around the country. So we're really looking forward to engaging with you. Thank you so much for joining us, Eric. And then to my far left is Professor Tony Sebok. Professor Sebok is the Joseph and Sadie Danciger. Danciger. I'm not sure I'm pronouncing that correctly, so forgive me. But he's an endowed chair at Cardozo Law School. He's also co-director of the Jacob, I'm going to get this name wrong too, Burns Center for Ethics in the Practice of Law. Professor Sebok is also a leading scholar on tort law and professional responsibility, and is also the author of Aspen Publishing Company's casebook on third-party litigation finance. We're really honored to have all of you here and joining with us today. So the way we'd like to get started is by inviting our three panelists to take some time to talk about generally consumer protection concerns or issues in third-party litigation funding. And why don't we begin with Professor Sebok, and then we'll go to Mr. Schuller, and then finish up with Professor Avraham. And then after that, I'll ask some questions. We'll have some discussion, and we'll invite you all to join this conversation through the Slido.com app. Professor Sebok?
Well, thank you very much. So I'm thrilled to be here. This is a beautiful law school, and I appreciate the invitation and the hospitality that's been shown to me so far by the Law Review, Professor Anderson. It's been great. I'm also very happy to see virtually my co-author and friend Ronen. I'm sorry you're not here, Ronen, but it's good that you were able to join us in any event. And of course I see Eric too, but I mean, Ronen and I have been working together for a long time, so I'm really happy that he's able to join us, even if only virtually. Now, I asked to go first because I wanted to, in some sense, subvert the topic a little, not in a perverse way, but I think helpfully, I hope. Because I want to open up the question of who is the consumer in the conversation that we're supposed to be having here on consumer protection. And I don't think what I'm doing here is just sort of for the sake of argument. I think there's a point to asking that question. It doesn't get asked, I think, as frequently as it ought to. So I guess I'm going to ask that question, and then once I answer the question by giving some candidates, I then want to point out that depending on what the answer to the first question is, there are, of course, two subsequent questions you want to ask. I'm not going to answer those really. What is the interest that we're trying to protect of that consumer? And then finally, what is, to sort of use this kind of buzzwordy expression, what is the right size approach? The right size approach is like the least restrictive approach that was mentioned earlier by William Mara. What is the kind of all things considered right approach to protecting the interest of the consumer that you've identified, given all the different various goals we have in regulation and in public law? So, there are some candidates for the answer to the question, who is the consumer? You might think this is obvious. If we were to simply use conventional industry or trade lingo, then we know who the consumer is. That would be the counterparty in the contracts in contracts extended by companies represented by Eric and another organization called Alpha. We have this industry or marketing term called consumer litigation finance. I have used it with Ronen. The study we did that was published in the Cornell Law Review was an empirical study of a consumer litigation finance company.
There's a company who everyone agreed was a commercial litigation finance company. It was not an insurance company. It was a company. What made it so? Well, you look at the characteristics. I think all of it is going to. You look at the characteristics of the counterparties. These were typically occasional market participants. Normally, we would call consumers the kind of people who have full-time jobs doing something else other than making money. They had small claims, typically personal injury, workman's comp, and they were one-shotters. They weren't repeat players in litigation. It's a very, very simple description. And I certainly don't think it's false. It's just to be under-descriptive because they may not be the only consumers we have to be worried about. But they have certain characteristics not only having to do with their biographies, but also having to do with their education and their financial situation and in their and the nature of their claims. But that's what people think, though, when they think about consumers. But listen, that's not necessarily consumer who might need protection. So, for example, think about the owners of the patents retrieved by IT Edge and Nakatar in this well-known Delaware story, right? Mark Hall, sole owner of Minutes. This is not somebody who looks that different than a counterparty, so if it's dealing with a litigation finance company like Wabash or Oasis. Mark Hall is not, as far as I can tell, a very sophisticated person. He had no beneficial interest in terms of liquid assets in the claim he had, much like a personal injury plaintiff who might be dealing with Oasis or Wabash, right? He had no actual liquid assets invested in the claim he held, capital risk. What he did have, theoretically speaking, was perhaps some exposure. He admitted that he had a risk of liability. In cases there was an adverse cost judgment, although I really wonder whether anyone really believed that. So was he a consumer? Does he need the audit in our consumer protection discussion? What about the owners of claims, meaning plaintiffs, have chosen action in mass torts? These are the people who are mentioned as the players, one of the players in some of the persecution Arik's work on OK Capital. Are they consumers? Well, they are certainly small people. They are workers. They are people that are consumers. They're no different in their biographies than the consumers who we worry about in consumer protection when we talk about people who are protected by consumer litigation finance reform laws directed towards Oasis and Wabash and the charity speaks for. There too, their investment in their claim is just like that of a first injury claimant. They have an expectation of compensation, but they have no actual capital at stake. They have contingency fee attorneys, and actually, what we really are worried about there, according to Arik, is that we're really worried about, in some sense, the conflict between them and their lawyers, not so much the conflict between them and funders. And then there's other groups of people to be considered. Example, about the counterparties in the accrued financial case. Finance, the accrued financial case report cert in 2002, famously, because you all these things, it's like crown jewel in my caseload, I think. You know, it's a case in which you have business people, they're not really sophisticated, but own card shops, or people who own clothing stores in malls, who have been approached by litigation. Not only to under like who's represented by Art or by Alpha, it's a litigation funder who instead approaches small business people, art shops, and says, you know, just like a art tenant, they're a commercial tenant, but just like a resident. They have unrealized claims against your landlord, this big shopping center, and in exchange for what appears to be an assignment, but they're truly an assignment, because the contract is extremely vague about whether or not we pay the fee aside. Ultimately, the decision to settle remains with the tenants, so it's not true. It's technically insider. In exchange for between 40 and 50% of the expected recovery from the predatory landlord, the litigation finance company will handle everything soup to nuts, retain the lawyer, and keep half of the recovery. And if the counterparty, this consumer, doesn't want to continue, that's okay. They can bring it into that. They just have to pay a kill fee to the person they sign up. Are they a consumer? Do they need protection? The court thought so. The court thought that this is predatory behavior, and that one of the reasons why it should be kept against policy was the vulnerability of the right. And so, you know, ultimately, you know, I just want to say you can even extend the definition of influence to that. So imagine level of representation by lawyers who take investment from non-lawyer capital providers, whether they be PI lawyers with a firm that does PI or med mal cases, or they be lawyers who do house liability fix for individual client, or they are lawyers who do commercial litigation conflicts. And those lawyers are not actually, and those lawyers are the ones who are the counterparty for the litigation finance. This is what we call lawyer-directed litigation. What about their clients? Are there clients that we're trying to protect? Because after all, their interests are going to be affected by the litigation finance contract between the financier and the lawyer. Are they also consumers who we want to protect? So I just want to make sure we understand that when we start talking about consumer protection, and if we come up with what we think are metrics or norms that we think are persuasive, we should ask ourselves, can they be scaled up? Can they be scaled out? Can they affect other kinds of transactions that don't normally get included in the narrow characterization of consumer litigation finance that I don't want to accuse anyone here of using, but which I use all the time, right? The kind of characterization that I used when I wrote the article with Ronen. So then I'll conclude with the two final observations. I mean, obviously then the interest to be protected might vary across these different types of consumers, but there are generally two kinds of interests that always pop up. And this is why I think this is a worthwhile way of thinking about it. One is the consumer, whoever they are, that they're interested in their net recovery, right? Are they getting a fair price for what they've given to the funder? And actually, you think about all these five different, maybe 4 out of the 5 mostly, but even the 5th categories I've suggested, that's always a question which the regulator, which the person concerned about regulation is going to want to know. Is it a fair price, right?
And then the second, and this is, I think, ancillaries and true about all 5 of these, is control. Like, how much control is the consumer as counterparty giving up, and should we allow them to give up any control over the material events of their litigation? And so those are, I think, the sort of interests that we want to see protected. And what I will say, speculatively, is that the right size or the least restrictive type of measures to protect the consumer, depending on how you denominate the consumer, to protect these two types of interests, which I think are through lines through all of these different kinds of consumers, will be very different depending on the specifics of that consumer. And I'm going to stop right there.
Great. Well, next, can we turn to Eric? And apologies, everybody, both online and in the room. We've been having some trouble with our microphones. All right. Looks like these are back up and running, and we've also got a backup mechanism now. So thanks, everybody, for your patience as we deal with our audiovisual challenges. But Eric, why don't you take it away? Share some of your thoughts with us.
Sure, appreciate it, and I appreciate the invitation. Let me just level set based upon our previous panel discussion, the difference between consumer legal funding and litigation financing. Consumer legal funding, just give you our average funding to a consumer is about $3,000 to $5,000. On the litigation financing end, most of them typically start around $3 million. Just a couple zeros difference. I had one legislator tell me it was a government rounding error difference. What the money that we give a consumer is used for household needs. Pay the mortgage, pay the rent, make sure you got a roof over your head, pay the electric bill, put food on the table. It's specifically designed not to be used to fund the litigation. It cannot be used to fund expert witness, attorney's fees, court costs, things along those lines. It's only to be used to make sure you can survive until your case is adjudicated. Give you kind of an example of how this works. So let's say you're driving home from work from one day and someone hits you, you get injured. Because of your injuries, you can't work for a couple of weeks, but now you're back at work. But because you missed those couple of paychecks, you've fallen behind your mortgage, rent, car payments, and you've retained an attorney, and you go to your attorney and say, where are we with this case? And they said, well, we've got a good case here, but it's going to be at least, 18, 24 plus months before we get a final resolution on it. And he said, okay. And as you're going through it, all of a sudden, about 6 months later, you're short because you've missed those paychecks. And you go to your attorney and says, hey, I need some money today. Where are we? And they says, well, we've got an offer, but your case is worth X amount of dollars, but we only got a couple grand as an offer. It's not even going to cover anything. What our companies will do is take a look at the case and say, based upon our experience, your case should settle for X. And typically they fund no more than about 10% of what they think the value of the claim is. Not what the attorney thinks, but what they think the value of the claim is. And they're going to be a lot more conservative than the attorney. And then fund the consumer that amount of money with the attorney's permission. If the attorney does not think this is in the best interest of their client, the transaction doesn't happen. Their attorney reviews the contracts, makes sure that all the I's are dotted, T's are crossed, and this is in the best interest of the client. Once that's done, the money is then given to the client, and then they step back. They have no say in the settlement process. They have no interaction with the attorney at that point, other than just maybe once every 6 months, hey, Mr. Attorney, where's the case at? Things like along those lines. We have no interaction as to the day-to-day operations of the case. Once the case is settled, the attorney then cuts the check, and then we get paid last. So in other words, attorney's fees, medical liens, statutory liens, they all get paid first. Once that is done, then the funding company gets their money. And then the consumer gets paid. There have been instances where people have said, well, the consumers walk away with nothing because the consumer legal funding company took all their money. That's 100% impossible. Because you remember, the consumer got part of their settlement up front. They got it when they needed it. It's kind of the old adage, when do you need a parachute? When you jump out of the airplane or when you land on the ground? They got it at a time in which it was important to them. The other thing that we've done, we love regulation. Our organization is promoting regulation. We'd love to have 50 statutes, 50 states. Because not only does it bode good for the consumer, it also bodes well for the business. It puts guardrails on what the companies can and cannot do, what the attorneys can and cannot do, and what the rights of the consumers are in it. I was here a few years ago, in Utah, and Utah has a very good statute on the books on consumer legal funding. It requires notice and disclosure to the consumer. In other words, they need to know exactly what is the cost of this product going to be, right down to the penny. It has it that the companies, by statute, cannot have a say in the settlement process. It also extends, what was brought up before, the attorney-client privilege to the funding companies. This is important. We need to have that honest and open discussion with the attorney to say, is this a good case or not? And then also clearly defines what the repayment process is. Companies are registered with the state. There has an annual report that they all have to do. And I can tell you right now, give real good examples, both Utah and Oklahoma. We have seen examples in both those states where we have funding companies who have started up in those states after the statute is passed. It has spurred local businesses. And I can tell you that those local businesses are giving the national players a run for their money, because they can say, hey, I'm right here in Salt Lake, or in Oklahoma, I'm right here in Oklahoma City, or I'm right here in Tulsa. You don't need to deal with that guy in New York, or that guy in Chicago, or that guy in Los Angeles. I'm right here. If you have an issue, we can talk together on it. The one thing I always want to make sure everybody walks away from this is that consumer legal funding is a financial transaction which consumers can use to leverage an asset they have. And that asset is the potential proceeds of their legal claim. And I'll stop it from there and continue on.
All right. Thank you so much. Next, we're going to turn to Professor Avraham. Take it away.
Hi, everyone, and thanks for inviting me. Good to see you, Eric. Good to see you, Tony. Before you switched the microphone, I could barely hear you, but it seems that you said smart things. I trust you. But I did hear Eric very well. So few things. So as Eric suggested, we should distinguish between consumer litigation funding and what Eric called litigation finance, and Tony and I called it commercial litigation funding. So it's a different story. It's a different market. It's a different species when we have consumers, just like Eric described, versus when we have sophisticated parties that need much less protection. And Tony mentioned control. I personally see no problem why sophisticated parties could give control to funders. But I don't want to talk about those sophisticated parties. I want to focus on consumers, because we're talking about consumer protection laws. Based on my studies with Tony, actually, I think all of my studies are with Tony. Tony also had some of his own studies, but based on our empirical studies, I have developed some views about what needs to be done. These views are mine. They do not necessarily represent Tony, although I hope he will join me. But I don't know. We'll see. One thing is that the market for consumers should be further divided between what we call post-settlement and pre-settlement. So post-settlement is funding that consumers or litigants that have won a case or a settlement, but it's going to take months before they see the money for various reasons. But there's no longer litigation risk. It's just liquidity. It's like almost like a normal loan. We discovered that at least up to a few years ago, this market was not running well, in the sense that funders, for lack of a better word, exploited consumers' lack of understanding of what's going on, and they were charging them very high interest that do not reflect any real litigation risks. They kind of treated both types of fundings, post-settlements and pre-settlements. I'll talk about pre-settlements is what Eric described. Basically, it's before you know what's going to happen in their cases. You're going to wait 18, 24 months. So there's a lot of not just what we call financial risk or financial risk in the sense that, time value of money. It's not just that. There's a lot of litigation risk. And that justifies high interest rates, especially because these are on a non-recourse base, meaning that if the litigant loses, the funder sees nothing back. So there's a lot of risk, and it does justify, in my view, high or higher at least interest rate. But with post-settlement,
There's no litigation risk. It's just time value of money. You cannot defend funders taking the same interest rate in both these markets. So proposed settlements markets, we think that regulators should take better care and protect consumers better than they did so far. But that's a relatively smaller market. So now I want to focus on the market Eric focused on. And actually, I'm a fan of this market. Besides the advantages that Eric described, where you're helping disadvantaged consumers or consumers that are weak, financially weak, you're helping them to get their day in courts, which is very good. There's another advantage, which we often forget, and that is maintaining deterrence with defendants, especially if those are repeat players. If defendants know that they can get away with it because they can exhaust plaintiffs into lowball settlement offers, then there's not enough deterrence coming from the market, and we're going to see more accidents and more torts than we should. So in that sense, and that is often forgotten, litigation funding fixes the market, reduces the number of accidents. So that's another advantage, which is, again, a reason why I'm a fan of this industry. However, we're still worried that, or we don't want to see this funders taking advantage of weak consumers. We like to see them helping them get their day in court, and we like to see them helping them creating deterrence towards defendants, but we would not like to see them charging them interest rates that are not connected to any real financial risk or litigation risk. So what do you do with that? How do you regulate them at a minimum possible level? And here what we've discovered is that disclosure is not good enough. So telling consumers about the interest rate, let's say 2% a month, most people will think, well, 2% a month is 24% a year. Maybe that's justified given that it's a non-recourse funding and that the funder may get eventually nothing back. Maybe 24% is justified. Actually, in my view, it is. But the problem is that sometimes funders stick in all sorts of kind of fine print things like compounding interest. We all survived Corona, so we now understand what compounding means and how things that grow exponentially grow much faster than our brain can easily imagine. So when you have compounding interest, interest grows, the money you owe grows exponentially, and it becomes a lot of money to pay back. So I would like, if we are serious about disclosure, I would like to see a simpler disclosure. I would like maybe to eliminate compounding and all sorts of other tricks that exist, hidden fees and stuff like that, and be honest. Tell consumers, so suppose that 24%, 2% a month, which is 24% a year, once compounded brings you, let's say, to 40%. Be honest and say 40% upfront. So consumers know that this 2% a month is really 40% a year. And they'll decide whether they want to take it or not. I'm not suggesting to regulate the prices. I'm just saying disclose it in a way which is really helpful for non-sophisticated parties. So that's point number one. Point number two is that in general, we should be skeptic about strict regulation. So what I suggested was a soft regulation, kind of rules of disclosures that are simple to understand, even for those who, like most of the universe, do not really understand exponential growth of debt. So that's kind of a soft regulation, which I think can be helpful. And why do I settle with a soft regulation? Because based on our research, we saw, that's a forthcoming paper, we saw that strict regulation doesn't work. If regulation can be circumvented, it will. If it's too restrictive and it cannot be circumvented, funders will leave the state. So closing the loopholes is really, really hard. If you're too good in closing the loopholes, funders will leave the state, and that will harm consumers for the reasons Eric and Tony mentioned. And if you don't close the loopholes, you just encouraging funders to circumvent them and making everything more expensive. So you should not be shocked that I argue that regulation is expensive and is not really helpful. We tried to regulate alcohol during Prohibition, didn't work. I'm not, of course, comparing funding to this. I'm just for the kind of sake of the argument, just to show how hard it is to regulate stuff that the markets really, really want and need. War on drugs didn't work, opioids, abortions. Very hard to regulate things that the people want. And in our forthcoming paper, we call it the whack-a-mole game. You close one loophole, they'll find another. And again, you just make things more expensive and you don't benefit anyone. So what's the point? So what is the solution? Unless you regulate at the federal level, so funders cannot switch states based on the benefit that they receive in every state, and that has its own problems. Do we really want the federal government to regulate consumer protection? Some may say yes, some may say no. It's a complicated question, but it's definitely not a panacea. It's not a magic pill. It has its own problems. So if you don't do that, what can you do? So beforehand, I mentioned the soft kind of an honest disclosure of the full amount. Another possibility that we discuss in our papers, Tony and I, is that maybe consumers should be protected with some minimum guaranteed return. So they know that no matter what, they step back, they go back home from this litigation with, I don't know, 50%, 51%. They get the majority of the money from the litigation. So that's another idea that I think Maya Steinitz was the first one to develop that. And I think it's not a bad idea at all. Another lesson from our research is that sometimes voluntary agreements work best. And we looked at New York. New York had a voluntary agreement with the Attorney General there, and of the industry with the Attorney General, and the prices went down. It's actually probably the most successful regulation for litigation funding that exists in the United States, in the sense that it did bring prices down because the industry and the regulators agreed on the terms. And I was surprised by that. Actually, I thought that my kind of initial was that probably those voluntary agreements work best for the industry, but no, our empirical research suggests that in New York, it worked really, really well. So these are my points about the past, what we've discovered about the past. I want to conclude with a few things, just kind of to think about the future. Where do we go from here? So I want to mention three things that I think are interesting. Remember, I talked about how this industry, the litigation funding, does not just provide or help the disadvantaged get their day in court, but also fixes the world in the sense that it provides better deterrence to defendants. So we see less accidents because deterrents know that they cannot buy their victims with lowball settlement offers. A place where I see that is maybe rising in Israel, I'm not sure, is consumer class actions. And it exists in the United States, but I think we're going to see more and more of it, more and more funding of consumer class actions. I'm just kind of guessing. It's not really even a hypothesis or prediction, but I think there's a good chance we're going to see more and more of that. And that is even, in a way, that can help many more consumers and provide better deterrence. So I'm curious to see how this is going to develop. So this is point number one about the future. And I know it already happens in the United States, but I think we're going to see more of that. So it's a kind of a combination of commercial and consumer, because we protect consumers, but the money involved is at a commercial level. It could be millions of dollars of funding, but for many, many consumers. So it's an interesting market to explore. If you guys have access to data, Tony and I would love to look at it. Point number two is, another thing that I've noticed is that there are now companies, startups that are mining the internet, mining data from the internet about all sorts of violations. Could be privacy violations, other stuff of violations. And they're trying to build their business models based on sharing profits with lawyers.
and as Tony can tell you much better than I could, all sorts of ethic rules in most states, maybe but Texas, prohibit lawyers sharing money with third parties. And I expect to see this rule being attacked or shaken, or I'm curious to see what's going to happen with that, because there's a lot of pressure from startups. And again, I think overall it's a positive change because they're now able with their AI tools to really fix things that beforehand just went broken, like violations of privacy. So this is point number 2 about the future. Point number 3 about the future, and here I know I'm stepping into a minefield, and I apologize in advance. There's a big debate in the United States about disclosure of plaintiff's funding to the other party, to the court. And as I told you, I'm a huge fan of this industry, and for a reason that I am not fully understanding, the industry is very much against disclosing to the court the existence of funding in specific cases. And I'm not sure, actually, I have 2 papers about that. Now I recall that I have papers without Tony litigation funding. I forgot about them. But I have 2 theoretical papers with Abe Wickelgren from Texas, where we show that revealing litigation funding to the court is going to benefit plaintiffs. And the story, and it's a mathematical model. We run simulations, and we kind of show what I'm going to tell you. But just to give you the intuition is that the judge can get a signal from the interest rate about the strength of the case. So here we have, as Eric described, parties who put their money where their mouth is. If the case is strong, they'll finance it with good interest rate. If the case is weak, they might not finance it at all, fund it at all, or fund it with a higher interest rate because of the risk. And this interest rate, we argue and we show in various simulations and models that this signal is going to improve the accuracy, and actually is going to help plaintiffs get a better settlement offer from the defendant. So it became so political that kind of Democrats and pro-plaintiffs are against disclosure, and Republicans and Chamber of Commerce are against disclosure, but at least my research suggests that it should be the exact opposite. So that's it. That's all what I have for you today.
All right. Well, thank you for those introductory comments, everyone. I'm going to go next to you, Eric, and if I could just set the stage, having read the empirical work in the Cornell Law Review that Professor Sebok and Avraham have put together, and my understanding is that a pretty typical consumer case involves a car accident is the most common example of consumer legal funding. And then you suggested, I believe, the typical amount was about $3,000 thereabouts that gets funded. My recollection is that the median amount several years back in the Cornell study was about $2,500 gets funded. And then the typical amount of time it takes from funding to the payback period after the settlement of the litigation is about 14 months. And then if you express that total amount of money that's going to be paid back to the funder, and you were to express that as a simple interest growth rate, it would be about a 42% rate of appreciation from the amount funded to the amount that's repaid. So it would grow from, say, $3,000 to about $4,260. Sorry, Tony, you want to jump in? Am I missing that?
Just there's a middle piece that I want to inform, which is that the projected recovery is higher than that, but the actual recovery is that because of post-performance givebacks by the funder.
Haircuts.
Right. So, sure, that makes sense. Just trying to level set there. That's what we're talking about. Consumer gets about $3,000, and then out of the proceeds of a slip and fall or a car accident lawsuit, not directly from the consumer, although most oftenly, I think most prototypically, the money would go to the consumer, and then the consumer has to remit those funds under their agreement to the consumer litigation funder. So I just want to get is that an accurate caricature of what the typical transaction is that we're talking about? And then I know you also want to chime in and respond to some of the stuff that your colleagues have said so far.
Yeah, I mean, to some extent, as Ronen said, and Tony's put it in their paper, and I'll never say this, this is not a cheap product. There's a lot of risk involved with it. And there's a lot of costs associated just offering the product alone. I mean, some of my smaller companies are paying between 15 to 20% for cost of capital, because this is not it's an intangible item. It's not like a machine shop where if the company goes belly up, you can go repossess tool and die machines or whatever it is. It's pieces of paper. So their cost of capital is sometimes 15 to 20%. So let's just say it's 15%. Cost of typically just doing business is about 10%. So now you're at 25%. Our loss rates within the industry, where right now where most companies get at absolutely zero, about 7 to 10% of the time they get absolutely zero back. And about 30 to 40% of the time, they're getting less than contracted amount. So let's just put that together and just say another 15 to 20%. You're at 35, 40% right there. And that's just to break even. There's a lot of risk associated with these types of products. Whenever I talk to legislators all the time, and they said, well, we'll put the Military Lending Act cap rate of 36% on you. And my gosh, I wish I could get 36% on my investments. Well, yeah, I wish I could get 36% every time, but a full 36. You have to take into consideration the cost of doing business, the cost risk assesses that go along with offering these types of products alone. There's a lot of risk that goes along with these things. You have to look at not only the value of the case, but also the value of the attorney. You have to look at that attorney. Is this an attorney that wins, 80, 90% of their cases? Or is this an attorney that only wins 10% of their cases? Those are intangible items that funding companies have to live with and go with. It takes a funding company typically 3 to 5 years just to figure out who the good attorneys are, because these cases don't settle quickly. They go on for quite a while, and their cases are going on longer and longer. I was talking to somebody recently in Rhode Island. They said time a case is filed in Rhode Island, by the time it hits the courts, 5 years. Some states are less, but a lot of states are drag these cases out a long time. And I'll just kind of touch base on some of the couple things that Ronen said. There are some case law on point and regarding the difference between pre-settlement and post-settlement. This is what case in Michigan, the Curry decision, and also in New York, the Yardy legal funding case. And in both those cases, the court has said, if it's pre-settlement funding, meaning you don't know what the outcome is, then it's not a loan. But if you do know what the outcome is, then it should be treated as a loan. I can tell you from a market standpoint, a lot of companies are looking at this, and just from a pure marketing standpoint, it's the capital market. It's the free market. They're looking at, hey, if we can still make money on this and maybe charge a little bit less, we can outdo our competition. Companies are doing that. As far as the disclosure of the contract terms, that's one of the things that we put forward in every single piece of legislation we put forward, is that the consumer knows day one exactly what the cost is on this. If you go into look at the contracts that are mandated by the statutes and also by our best practices of the industry, we work with the American Bar Association to develop our best practices. The consumer can look at their contract and see that in the top mark, if you get X amount of dollars, you'll know if the case sells in 0 to 6 months, it's this. 6 to 12 months, it's this, and all the way out. And we also mandate, and companies put on there, and sometimes in statute and sometimes as a best practice, that they will have a will not exceed number on there. So if the cases stop at 42 months, the fees stop at 42 months, if the case goes on 60, 70, 80, 90 months, everything stops at 42 months. We have that in a couple of states in statute. And regarding the
can I ask you a quick
Sure.
question, Eric? Are you against eliminating compounding interest and just disclosing, let's call it the simplest interest rate to consumers?
The problem with that is I, as a trade association, can't talk about dictating what rates should be, but I think the consumers should know what they should be. And their attorney knows what these contracts will look like. Consumers are going to typically deal with one funding company. Attorneys are going to look with multiple funding companies, and they're going to know the company A, company B, company C. And we've seen that, like I said before, in Oklahoma and here in Utah, where because contracts are fully disclosed to the terms and conditions to the consumer and to their attorneys, the attorneys can look at the contract and say, you don't want to deal with this company. You want to deal with this company over here. And so if they're fully disclosed and know exactly what the terms and conditions are, the market's going to dictate what those rates are.
Tony, did you want to chime in?
Yeah, so for the benefit of the audience, again, a little bit of table setting here. It's very interesting in different parts of American business and law. You discover the free market doesn't seem to be very fluid, and you get a lot of stickiness in pricing. One of the mysteries that people have been wondering about is how did the contingent fee seem to settle at what they claim is 33%, although that's a myth. It didn't really settle at 33%. You see people arguing about why do realtors have a certain percentage of interest, 6%? How did that get established? Why is that so sticky? Now, what's interesting about the litigation finance industry on its broadest definition, even going beyond what I was describing as the expanded definition of consumer, going to true commercial, right, is something which there's a stickiness which I do not understand. Some people in this room might be able to answer it for me, which is the pricing of commercial litigation finance, although it is bespoke and the contracts are very long, but from the very beginning, it seemed that one of the sort of polls that people would gather around in terms of starting off talking about pricing was multiple of capital advanced. Doesn't have to be that way, but that's the simplest way of doing it, as opposed to percentage of recovery, which is what lawyers do on contingent fee. And certainly nobody was pricing it on time. No one was treating commercial litigation finance deals generally as like loans were priced or mortgages. On the other side, in the consumer, we're happening exactly the same period of time in history. It's the opposite side of the spectrum. The default was a time-based price, not a multiple. I mean, it's an interesting question. Why doesn't litigation finance company for consumers extending $2,400 say, hey, if you succeed, you give me $3,600, not you give me something times the number of months it was out. I've never understood the stickiness of this pricing.
Ronen, did you want to chime in?
Yeah, no, I totally agree with Tony. I just want to kind of highlight the paradox here is that the sophisticated litigants get the simpler model, just a multiple, 3x, and the non-sophisticated parties get
Ronen, people in the audience who are sophisticated claim that you're wrong about this. I'm just letting you know, you can't see them shaking their heads.
Well, what I don't see doesn't hurt. Where is my mistake in their view? Is it the 3x for commercials or the compounded interest for consumers?
Multiple, plus an interest rate, plus a back-end participation that changes over time depending on what's going on in the case.
So the sophisticated people say that it's a multiple with a lot of other bells and whistles that you haven't named. But I mean, I think that's an important question, which is when we're talking about 100 deals, what does the median deal look like? I mean, I don't deny that there are, I'm going to let Ronen talk, and I'm not going to repeat what Andrew Cohen said, but I think these are interesting and important things to get right in terms of the facts. But I think I agree with Ronen that at the beginning, it did feel like the median deal was a multiple, and then there were variations and sophisticated additions made. Certainly it's different today now than it was 20 years ago. So I'm just going to let Ronen finish.
Well, yeah, so I'm basically done. I would love to see, I'm not for regulating prices. I'm not for regulating the interest rate itself. I'm just for giving consumers the simplest possible information. And Eric, I know exactly those tables that you describe in that various states have, that what happens after 24 and 36, it's still too much information in my view. And I would have loved to see either a simple form of interest or a multiple, and nothing more sophisticated than that.
Can I? Please.
Well, just a couple
ahead,
quick
Eric.
things that I wanted. One of the things that Ronen brought out was possible guarantee return of settlement. We've actually looked at that, and I've looked at that for a long time. We've got where we get pushback from is from the bar, because if we have to ensure that the consumer is getting a guaranteed X amount of the settlement, we have an obligation to see what that settlement is. We never see what the settlements are. The only time we'll get the settlement letter is if an attorney calls us up and says, hey, this was a dog of a case, and I had to take a haircut, the meds take a haircut. I need you guys to, we may just to make sure that the attorney is being above board with us. Hey, can we see a copy of the settlement agreement? We don't see the settlement agreements. And if you were having to ensure that the consumer gets X amount of money from it, that will require us to see the settlement agreements. A lot of times, some of these settlement agreements are confidential. So then we have to go to court now to get the judge to allow us to look at that. And so, like I said, we've actually looked at this issue, and we've tried a long time. And I can tell you, for 2 years, who now is the governor of Missouri, when he was a state senator, I worked with him for 2 years in Missouri to try and figure this out. And we just couldn't get it. It was the bar who kept pushing back on us. And regarding the disclosure of the contracts, where we give pushback and disclosure of the contract is where it's an automatic disclosure of the contract. In other words, without even asking for it, here it is. We'll never support that. This is a discovery issue. And in anything discovery, you have to request it. So we worked in Indiana, and they passed statute last year on disclosure, in which, if requested, the consumer and their attorney will acknowledge, yes, Mrs. Jones has one of these transactions. And then it follows the normal course of discovery as to whether or not you need any more information on it. But in the end, it's inadmissible against the consumer. So you can't go into court and hold up a piece of paper. This is one thing that a couple of attorneys when I talked to said, and there's one attorney that sticks in my mind from Georgia told me. He said he didn't think anything of it, and he got asked of whether or not his client had consumer legal funding. He says, yeah, here it is. Here's a copy of the contract. No big deal. They go in court. First thing that the attorney on the other side does is picks up the piece of paper and says, well, if you award Mrs. Jones this money here, it's not going to Mrs. Jones. It's going to this company in New York City. They're the ones who's making all the money, not Mrs. Jones. Well, he got a settlement, but it was a whole lot less than what he expected to be. And but talking to some of the jurors afterwards, the fact that had an impact on it. So again, when disclosure, we never will support an automatic disclosure provision. I think it's the same way on the commercial side as well, too.
What is so these are financial products. The federal government, Congress has created a consumer protection agency to deal with consumer finance in America, the Consumer Financial Protection Bureau. There's a whole host of federal laws that it oversees, including the Truth in Lending Act, the Fair Credit Reporting Act, the Equal Credit Opportunity Act. What has the CFPB said about consumer legal funding? Do any of these statutes apply? And is there discussion of a regulatory approach from the federal government that connects this marketplace to the existing edifice of federal consumer financial law?
So there are other people in this room who probably can answer this question with greater knowledge than I can. As you know, my colleague Miriam Gillis is an expert on the CFPB as well. My response to you is actually going to be perhaps uncooperative, which is the following. My understanding is that the CFPB at the federal level, and then we could look at other parts of the federal regulatory apparatus, including the securities portions of the U.S. federal government, have avoided taking on within its regulatory mandate this part of the American commercial activity, this part of American commercial activity. Now, notice I stumbled there because I'm going to say something which perhaps you're not going to agree with. I'm not quite sure that if we're going to start using sort of the language of the street, that these are financial products. I don't think these are financial products. I look at them as a sale of an asset. I'm not really expecting the CFPB to start telling me how much I can sell my 2018 Subaru for. And I'm not expecting the CFPB to tell me how much I can sell a patent for. And I'm not expecting the CFPB to tell me how much I can sell my labor for, even though minimum wage laws are pretty good for the states. Especially in consumer in the most narrow sense, the way that Eric and Ronen defined it. I want to be clear. Since we have a contingent fee system in the United States, the dollar that goes out of the funder's pocket does not go into enhancing the value of the litigation. It is not a capital investment of any sort. It doesn't go to expert fees. It doesn't go to pay for the lawyer. To me, a financial instrument could either be a form of debt or it could be an investment. And actually, these are neither. I'm going to stop there.
Well, I guess language of the street. Most people, I think, in America, when they find out that what the product does is the consumer gets cash today, and then in 14 months, based on your study, they're going to give money back to someone, and they're going to give more money back than what they originally got. A lot of people will say, oh, that's a debt, and I'm paying back my debt.
So let me ask you a question. So if I get cash today and I promise that I'm going to give you labor tomorrow, what is that?
You tell me.
I mean, to me, it's a contract. It's a contract for services.
Yeah.
I mean, just because there's a time dimension to it doesn't immediately make it a financial device.
Well, so you could characterize what's happening in at least two different ways. The way that the industry wants to characterize it, it seems to me, is it's a purchase of a receivable, an asset, and there's not a periodic interest rate that's being applied to it, but there's a proportion of that money that's going to come back. That's one way to characterize it. Another way to characterize it would be that it's a loan with a non-periodic finance charge and an express condition precedent on the borrower's obligation to pay that's contingent upon the settlement. Both of these two uses of words graphed across the top of the pattern that's taking place. And what's happening is there's money exchanging place, and then we have some ink on paper or pixels on a screen that characterize what's happening in the transaction. And we can imagine that people are going to definitely be interested in going all in to try to decide which of those two characterizations we're going to have, because if it's characterized as a loan, there are a whole bunch of consumer protections that have been fought about in much bigger markets. Then all of a sudden, the players are not a couple of litigation funding companies, but or should be consumer legal funding companies. It's Bank of America and J.P. Morgan Chase and Wells Fargo and all of the payday lenders in America and all the merchant cash advance companies in America, and literally 4,000 or 5,000 years of legal history in trying to decide how we're going to cap prices on that. So I get that you don't want to call it loans, but a lot of Americans probably would call it a loan.
Okay. If you have something you need to blow your nose with, do you call it a facial tissue or a Kleenex?
I call them tissues.
Okay, but I think most people call it Kleenex.
Well, it's okay.
My point is that in every single statute we've passed, nowhere does it call it a loan. And in fact, in majority of the statutes that have passed, it carves them out of the loan statute. The state of Washington this past year.
Statutes that your trade association has lobbied for and passed don't call it loans. This doesn't mean it's not a loan, though. It just means that you're a good lobbyist, when you clearly are.
In the state of Washington, they decided to redefine what is a loan. We had nothing to do with the introduction of the legislation. When the legislation passed, it clearly carved out legal funding out of the statute because they realized it's not a loan. In courts around the country, to include a couple weeks ago, let me finish, please. A couple weeks ago in New Jersey, the appellate court struck down a case against Covered Bridge that said that these products are not loans. New York has struck down this saying they're not loans. Texas, Georgia, Minnesota, Wisconsin, several states have interacted and says these products are not loans. A loan is a guaranteed some certainty of repayment, meaning if I give you $1 today, no matter what happens, I expect my $1 back. And if I don't get my $1 back, I can do something negative to you.
No.
The IRS has also weighed in on this and said litigation financing is not a loan. If you do it as a loan and you don't get your money back, then you have to 1099 the person. If you do it as a legal funding transaction and you don't get your money back, there is no debt created. Therefore, it's not a loan, and you don't have to 1099 that person.
Ronen, would you like to chime in? I see your hands up.
Yes, thank you. I want to argue that even though your question is super sharp, it's not a relevant question. I mean, we've been arguing, the United States courts and regulators have been arguing about this very exact question for at least a decade, maybe a decade and a half. And as you can see, no side has convinced the other side. So I suggest that let's focus on the normative dimension, not on the legal positive one. Let's not ask what is a loan, what is not a loan, how courts should interpret. Let's not ask that. Let's ask from a substantive perspective, what type of protection do these litigants, call them consumers, call them Yodas, I don't care. What type of protection these litigants need? And I'm willing to call this transaction any word you want. Any word you want, I don't care. Let's just talk from a substantive perspective. What do those people need? And I think that you will discover that you and Eric are not so far apart from each other.
Well, oh yeah, please go ahead. A member of the audience, for those who are at home, is raising her hand and wants to chime in. And we've also got some questions on Slido, and I've been hogging the questions here. So yeah, and I'll repeat your question for folks at home.
Thank you. Hi, I'm Victoria Sahani. I wanted to highlight actually what Ronen is asserting here. The CFPB has actually taken a similar view. So in 2022, they came out with an announcement that they were going to regulate what they call non-bank entities. And there's a whole description of what that includes. It can include the payday loan industry, private student loans, student and auto loans, international monetary transfers. And here's a key quote here. It says, quote, Congress also authorized the CFPB to supervise non-bank financial companies where we have reasonable cause to believe the company is posing a risk to consumers. There are many indicators of risk, but the law specifies consumer complaints as one indicator of risk. So the question is not really whether the product is a loan, but whether or not consumers are complaining about problems with the product. That's how the CFPB is looking at this in terms of these non-bank entities.
So just repeating back for folks at home, because remember, there are probably more people watching online than in the room, and it was a lot. But the general point, I think, is that the CFPB has announced that it's going to look at a lot of non-bank, non-depository financial companies, and they're focused on particularly on consumer risk. And our colleagues' characterization of the Bureau's position is that the most important question is not whether it's a loan, but whether or not there are consumer risks associated with that. Is that a fair?
So I have a question to Victoria, but as a general question to follow up. Okay. Risk to the consumer as evidenced by complaint. Now, I don't think that should be sufficient because clearly, or even necessary, because clearly consumers may not be complaining, right? We should still act to protect them. But I want to focus on the risk to consumer because I was pushing back a little bit. There are many things I have an interest in as a natural person with assets. I have a lot of assets. I probably have more assets than some small companies do because I'm a very privileged person. But still, there are many things I'm concerned about. One is I'm concerned about risk posed to me by predatory lenders. I'm also concerned about risks posed to me by predatory buyers, right? Or predatory counterparties in contracts. Now, my understanding from what Victoria said is that CFPB is focusing on risks posed to Americans from lending and lending-like institutions. And I'm still pushing really hard, and I don't know where Ronen comes down on this, but again, if I am a clearly identifiable vulnerable class of persons because I have an asset that can be from a predatory perspective, from a predatory counterparty, I could be taken advantage of because I could be tricked into selling my asset too cheap. Is the right competency a competency for protecting people against predatory lenders or is it some other competency? Again, the reason why we have minimum wage laws, right, is because someone decided at the state level that people shouldn't be allowed to sell their labor too cheap. That is a worthwhile thing to do, but it's not the same thing as regulating consumer lending.
And to that point of what Victoria brought up, we really don't have any complaints in this issue, in this space. And I monitor that all over the place. And the number one complaint that our companies get from the BBB is, I have a case and you didn't give me money. Or I asked for $10,000 and you only gave me $1,500. You're a bad company. Well, I'm sorry, but your case isn't that good. These companies are not in the charitable, they're capital companies. They're out to make markets, to make money. And in regards to the CFPB, the case I was cited in New York that said that if it's pre or post settlement was with RD Legal. And the plaintiff in those cases was the Consumer Financial Protection Bureau and the New York Attorney General's office. That's who brought the case in which that was decided. And by the way, that case settled for $1.
Well, let's turn to some of the questions from the audience that have been submitted to Slido. First off, in what ways do these funding agreements affect the ethical obligations of attorneys, especially regarding informed consent and conflicts of interest? Tony, you want to take that one?
Yes, so full disclosure or self-promotion, I do have an article about this, which basically goes through, especially in the area of consumer litigation finance as narrowly defined, the responsibilities in professional ethics of lawyers. And I'll just put it this way, and the article basically says it's not that sophisticated a problem to solve. The architecture of the duty of a lawyer to their client is not altered and cannot be altered by the introduction of this new financial relationship. It's even, in comparison, for example, to the alteration of the relationship of a lawyer to their client with regard to the existence of a liability insurance contract, in some sense, it's far less dramatic a change. Lawyers do actually come under tremendous pressure, and it's very difficult still to work out how they can be both loyal to their client and to a liability insurer paying their fees. That's not what happens here. Here, the loyalty of a lawyer remains entirely to their client. And the only material risks the client posed to a invasion of the lawyer-client relationship would come from a lawyer engaging in a faithless decision, which they shouldn't do, for which they should be disciplined. And if the inducement for that faithless decision comes from a funder, then the funder is essentially acting in a way to encourage a lawyer to violate the rules of professional responsibility, which no funder should do. Interestingly, while I've seen funders ask lawyers to do things which I believe are, in fact, superficially and facially in violation of the lawyer's obligations, they are often of no material consequence because no one ever puts them to the test. So, for example, if a funder attempts to get money from a lawyer from the lawyer's trust account that is under contestation, the lawyer inevitably, regardless of whatever it is the lawyer told the funder 12 months earlier when they signed some kind of lawyer's letter or some kind of side agreement, the lawyer never actually performs what they promised to do. I've seen one case only, where there was a suit by a funder against a lawyer for misappropriation of its funds, and they lost that case. It can be annoying for a lawyer to do that. My recommendation to lawyers is sign no side agreements with the funder, but the client in the end is not put at risk.
Well, another question posed by one of our audience members is some ground that we've already covered a little bit. What types of consumer protections are necessary for third-party litigation funding? Interest rate caps or other contract restrictions? And let me add to that. I know that everybody on the panel clearly thinks this is absolutely not a loan. Reasonable minds might disagree about that. And I know that, Ronen, you've suggested that you don't support regulatory price capping. But I could just set the table for the question. A supermajority of Americans, by far, it's not even close, Republicans and Democrats, support usury limits. They're one of the most popular forms of regulation in America. Any time in the history of the American Republic that it's been on a ballot, they've always been voted in favor of a traditional interest rate cap. If no one on the panel is willing to say that we should cap prices with a historical periodic rate cap looking back, what type of a price cap would you support?
A market rate cap. And
Meaning just whatever the consumer agrees to?
So let me just give you kind of the flip side of this. So let's say you have two car drivers. Both drive a 2020 Ford Explorer. One in the last 7 years has had 3 DUIs and 2 speeding tickets, and the other one has, in 35 years, hasn't even a parking ticket. Do they pay the same amount of money for car insurance? No, because the insurance company is risk assessing as to what their possibility of payout's going to be on both consumers. That should be the same thing here. By putting a rate cap or price cap or profit restrictions, whatever you want to call it, in place, you're telling those funding companies that they can only take those cases that have X amount of risk to them. Now, do I agree 100% the consumer should know exactly what it was? And if I could put in statute that these contracts have to be written at a 6th grade level, I would put that in statute. But I've tried that and I get pushback all the time. They need to know exactly what it is they're getting themselves into, and then make sure that the terms and conditions are fully explained to them.
Ronen, you want to chime in?
Yeah, thank you. So my objection to price cap is not ideological or principle, it's empirical. If my studies with Tony showed me that the prices Eric's companies charge are insane, I would have supported it. And remember, I started my comments today saying that in post-settlements, there should be a price cap, or they should be treated as loans, which basically means the same thing, because the interest rate they were charging were insane. But in the pre-settlement markets, it is not what I discovered. It's not what we have discovered. But if we had discovered something else, I might have well supported that. And the second empirical reason that I do not support that is that it's very hard to regulate it. There are many moving parts, hidden fees, all sorts of exit penalties, and legislators are not sophisticated enough to close all these loopholes. So what you're going to get is consumers paying the same thing, but even in a more hidden way. So I'm skeptical about the possibility to do that. And I don't believe that, at least based on the data that Tony and I looked at, there's a real need for that. So I'm kind of in agreement with Eric on the bottom line, but for totally different reasons. Now, I want to go back to Tony. Tony, you're a more free market person than I am. Will you object to consumer protection in the insurance market? I'm talking about consumer insurance. And if not, and I assume you're not against it, what's the difference? Why? I mean, they're kind of complicated transactions that normal people have no idea what they're getting into. I teach insurance law, you teach insurance law, and we both know how complicated this product is. And it's for us, and we are sophisticated. What's more for normal people? And all states, all 50 states have a commissioner. They have a special person that taxpayers pay called Commission of Insurance, who makes sure that people who buy insurance are protected. So why are you so against protecting litigants in the context of, I don't want to say the F word or the L word, I'm sorry, the L words, the loan word. But why not, what's the difference?
Well, and Tony, just to chime in, I think we're just about out of time. So why don't you take that as a concluding remarks for us today?
Right. So I am not opposed to regulation of the narrowly defined consumer litigation finance market, or more broadly, some of the other counterparties I described. I was really, and I don't think in a kind of petty way, pushing hard on the way we think about regulation. So, for example, regulation of insurance is actually famously not federal in America for all sorts of reasons. That's why the CFPB, if we say we want the CFPB to do it, I want to know why the CFPB, not other federal or state organs. And then the question literally, what is, to my mind, what are the interests of the consumer, how we define the consumer that we're trying to protect? And to my mind, the answer is not the same interest that the CFPB is concerned about with regard to risks to consumers as borrowers. To me, they're much more like what I was actually analogizing to minimum wage laws. It's the risks to persons who are vulnerable members of a market who are selling something who can be predated upon by more powerful and sophisticated actors. And we have an experience in this country with regulating those kinds of transactions. We can borrow from that. I just don't want to use the wrong tool to address the problem.
Well, it's been a vigorous and interesting conversation, and I want to sincerely, from the bottom of my heart, thank you all for coming to Salt Lake City, both in person and remotely, to have a lively conversation about consumer protection concerns, about third-party or consumer legal funding, litigation funding, depending on how we want to characterize it. And if you would, please, everyone, join me in giving our panelists a round of applause.